afternoon, friends. In the lecture series on investors protection, this is my fourth lecture on investors protection. In this lecture, I will be talking about the different type of reforms that is brought in by the SEBI for the investors protection purposes. As the new Companies Act, an amendment made by SEBI has improved the position of India in protecting minorities' interests. Some of the major reforms are, I'll be briefly, because these reforms itself are a subject of discussion in length, but I am not discussing at your level. I'll be not discussing them in detail. I'll be just talking them in brief. So there are certain amendments. I'll be talking these in a little bit later on, right? I'm just referring first. So there are certain amendments in the listing agreements, regulation regarding prohibition of inside trading, regulation of unpublished price-sensitive information. Now I'll be talking of these three in a little bit detail. Amendment in the listing agreement. See, what is listing agreement? So whenever a company wants to get itself listed on the stock exchanges, when I say listed on the stock exchanges, it means that the share of that company will be traded on the stock exchange. So, right, means a company has to get its share listed to become eligible for trading on a stock exchange. So, whenever the company wants to get its share listed on the stock exchange, there are certain agreements, there are certain terms and conditions which the company has to fulfill, and an agreement takes place between the company and the stock exchanges. There are some major amendments that were being made by the SEBI in the listing agreement. And the idea of the protection of these amendments is the investors' protection. That is, the interest of the investor is being protected. Certain amendments were made to clause 49 of the listing agreement to ensure better transparency and investors' protection, which shall apply to all listed companies. Means all listed companies which are listed on the stock exchange, barring a few, I'll be talking of that, right? So these companies have to fulfill certain conditions, so that, and these conditions are made in such a manner that the investor's interest is being taken care of. When I'm saying investor's interest, means there is a better transparency in the system. The common investor, the small investor, should have access to all the informations that can make an impact on the share price of the company. And time to time, they must acquaint themselves with the information what is happening in the company. So the various amendments were being made under the listing agreement. So all companies have to abide by this, except barring a few, like companies having a net worth not exceeding rupees 25 crore. So that small companies are being exempted from that. Companies having a net worth not exceeding rupees 25 crore or paid up equity share capital up to 10 crore rupees as on the last day of the previous financial year. Right. So these listing agreements which we talked in clause 49, in these listing agreements of clause 49, these companies exempted all those companies which are having a net worth of 25 crore rupees or paid up capital of 10 crore rupees or less. Right. So companies whose equity share capital is listed exclusively on the SME. Friends, SME means small and medium enterprise portal. Apart from the regular portal of the NSE and the BSE, the small companies, there is a separate portal that has been created for the purchase and sale of these companies, which are called small and medium enterprise portal. A separate portal is there for dealing in such companies. So these companies are exempted from the clause 49 of the listing agreement. So key provisions of listing agreement are, means what are the provisions, special provisions that have been created in the listing agreement regarding board of directors. See, the board of directors are the key positions, are the key persons who manage the affairs of the company, right? So what will be the composition of the board of directors? What are the qualifications of the board of directors, right? I mean, what will be the different powers and duties of the board of directors? These are all being given in the amendment. It has all been made investors friendly. Investor friendly means so that an investor, mostly the small investor's interest, is being taken care of. Setting up of an audit committee. I'll be talking about all these things. a audit committee is being set up, nomination, remuneration of the committee, what is the risk management system in the company, related party transactions, disclosure, report on corporate governance, right? So on all these issues, SEBI has come out with a guidelines. Let me tell you one by one regarding board of directors. The composition of the board of directors shall include executive as well as non-executive directors. Means there will be certain directors who work on a day-to-day basis. They are called executive directors of the company. There are non-executive directors who do not work on a day-to-day basis, but they are the experts, they are the specialized in different fields, and they are on the board to take care of the investors' interests with at least one movement director. In companies, like in order to have a fair representation of the women, a mandatory clause has been added that at least, and time to time it keeps on changing as per the requirement, at least there must be one movement director on the board. Similarly, chairman should be a non-executive director. In the board of directors, the person who will be the chairing the board, right, should be a non-executive director. Provision of independent directors with at least 1/3 composition in the board. Out of the total number of members on the board, at least 1/3 should be independent directors. Who are the independent directors? These independent directors do not work in the company. They are not the employees of the company. They are independent people having specialization in their own field. It may be law, it may be accounts like chartered accountant, can be good lawyers, it can be expert of any field. He may be a technical person, he may be a technocrat, right? These type of independent directors should be there in the board. Means these independent directors are not the employees of the company, but they come as in specialist people, and these gives their suggestions. Obviously, they get some remuneration of it, right? So independent director, 1/3 should be the independent directors. Establishment of vigil mechanism to check ethical behavior of directors and employees. There will be a vigil mechanism, means there should be a vigilance in the company, and then the vigilance mechanism should be such that even the conduct of the directors and employees of the company is subject to check, so that they do not take such measures, they do not take such steps, they do not take such decision making which harms the interest of the common investors. There is a provision of audit committee. The role of the audit committee is to ensure that financial statement is correct and creditable, right? See, in every listed company, there must be audit committee which will see to it that financial statements that is being presented to the shareholders, they are correct, and they are correct, not only correct, but their credibility should be there. Its role has been enhanced by specifying new rules like monitoring auditors' independence, scrutiny of intercorporate loans and investments. Not only their job is to see that accounts represent the true picture of the business, right, but also see to it that the auditors are independent. They are not being subject to interference by the board. Auditors, let the auditors' job be done by the independent people, so that the independence of the auditors can be maintained. Intercorporate loans means when one company gives loan to another company. Sometimes some companies, they have the common board members. Like a person may be having can be a member in the board of 4 different companies, right? A person can create 4 different companies, and these companies are related with each other. They keep on, if suppose there is an intercorporate loan. Intercorporate loans means giving loan by one company to another company, making investment in another company, right? So the intercorporate loans and investment must be checked, right? Nomination and remuneration committee. In each of the listed company, there will be a nomination remuneration committee which will decide that what will be the remuneration of the top officers of the company. Means officers means the board of directors of the company. The company shall set up a nomination and remuneration committee whose role is to formulate the criteria for determining the qualifications, independence, remuneration of directors and other key personnel. It is also devised a policy on board diversity. So this nomination, otherwise, because see who are the decision maker in the company. It is the board members who are the decision makers of the company. and board members themselves decide their own remuneration. If this committee finds that remuneration to the board members, to the chairman, to the other board members is not, it should not be fair, in that this committee can check the amount of remuneration that is being paid to the board member. The very idea is that shareholders' money is not being misused. The idea is that whatever the remuneration that is being given to the board members, the top people, the key personals of the company, which can include the auditors and all these people, right? So they must be given fair remuneration, fair honorarium. It should not be too high. Risk management system. Every company should have a risk management system. The provision of amended clause 49 provides for the constitution of a risk management committee. In every company, there should be a risk management committee. The purpose of the risk management committee is to monitor and review the risk management plan to the committee of the company. When I say to the committee means the committee's job is to see to it that proper risk management system should be there in the company. Related party transactions. What is this related party transaction? As I was saying in another point, that sometime a chairman or suppose a person may have 4 different companies. Each company is independent in terms of law, right? They have formulated, they are a separate entity, right? Although some of the board members are common, the promoter is common, and these promoters, say for example, you can say conglomerate. There are many companies I am not naming which are conglomerate. They have different businesses. They have paper business, they have hotel business, they have other types of businesses, right? So they are in the power business. So these type of companies where the promoters are common people, some of the board members are common, right? And what they can do is that from one company to another company, wherever the need is, right? That is this type of transactions is being made, money is being transferred from one company to another. These are called related party transactions. Sometime in order to serve, in the past especially, in order to serve the own interest of the promoters, they used to indulge in these related party transactions, but which may or may not be in the interest of a particular company. So there must be a check on these related party transactions. So a related party is an exchange of resources or services obligations between a corporation and a related party. Related party means when the party is related to when a party means even the company is related to the promoter or some senior officers of the company, whether or not a price is being charged, right? So this is called related party transaction. All related party transaction must be approved by the audit committee first. If there is any related party transaction, it must be it must be approved by the audit committee, which I have discussed in just now. All material related party transaction shall require approval of the shareholders through special resolution, and the related parties shall abstain from voting on such a resolution, right? If there is some significant material, and what is material, what is less material, it is a subject of debate. But as a rule, all material related party transaction, I can say as a layman at the moment, material means substantial, which has a huge amount involved, huge resources are involved. So these resources must get, these related party transaction must get approval of the shareholders also. Disclosure. There are very stringent disclosure schemes, disclosure systems introduced by the SEBI. Disclosures of the following shall be provided to the shareholders, like appointment and reappointment of directors. Who are the directors of the company, who are being reappointed, that must be disclosed in the annual reports of the company or the quarterly reports of the company, which are being published time to time, right? Annual reports including directors' report, right? Whenever the annual reports are being presented, it's the chairman gives the statement which talks about not only the performance but even what they are going to do in the future also, right? And directors' report should also be disclosed to the shareholders. Details of all material related party transaction shall be disclosed quarterly along with compliance report on corporate governance. Friends, these days corporate governance has emerged as a various scams which have taken place in the past in this country, not only in India but throughout the world. So these scams have made it mandatory on the part of the companies to have the top level of corporate governance in the company. So there are various reports, there are various mechanisms which have been introduced by the SEBI for the high standard of corporate governance. And practically also I tell you that all those companies which have high level of corporate governance, these companies enjoys very high price in the stock market, because when people, especially the foreigners who invest in the country, not only the foreigners, even in any large investor or any investor who invest in the stocks, right, see to it that the company where the investor is investing the money must have good corporate governance, high standard of corporate governance, and all those companies who are having high standard of corporate governance, they enjoy the better pricing in the stock market, right. So all this corporate governance disclosure means the companies are supposed to disclose in their quarterly reports about the corporate governance issues, right. So there shall be another aspect is there shall be a separate section on corporate governance in the annual report of the company. Means in each of the annual report there will be a specific reference of the corporate governance, what the company has done for the level of for the enhancing the level of the corporate governance. Corporate governance is an important component of company's annual report. It is a comprehensive report which states the compliance status of companies towards corporate governance, right. There are certain parameters, there are certain aspects which under the Companies Act are to be fulfilled, are to be undertaken by the companies. So what are the compliance status of the company in terms of the corporate governance? This has to be given in the annual report of the company. So it is a mandatory requirement which needs to be fulfilled by the company. The company shall submit a quarterly compliance report to the stock exchanges within 15 days from the close of the quarter in the prescribed form. The SEBI has given a prescribed format regarding compliance of corporate governance, right? And this compliance has to be undertaken within 15 days of the closure of the quarter. Means as and when, supposing starting with April, so April, May, June is the first quarter, right? So within 15 days of ending the first quarter, the compliance report has to be submitted to the SEBI. Regulation regarding this very important other aspect, apart from these board of directors, the things, right? So there is a corporate governance issue. Very important aspect in the country is inside trading. The SEBI is very strict about the inside trading. So there are regulations regarding prohibition of inside trading. The very idea is that inside trading is being prohibited, cannot take place in the country, so that any person who has some inside information about the company, which is a price sensitive information, he or she is not able to misuse. I will use the word misuse in the sense that by using that information cannot make some personal gains, or when I am saying personal gain means personal gains to him or to somebody else who is related to him, right. So there is a very strict act in India introduced by the SEBI for the prohibition, so that the idea is so that all investors are on the same footing. The very idea of prohibiting the inside trading is that any investor, even the smallest of small investor, must have an equal playing field, right? So that have equal information. No person who is having access to some inside information may not able to misuse this information, or may not able to use this information for making some gains, right? So any individual associated with a company and who has access to unpublished price sensitive information, like what is unpublished price sensitive information? Information that can influence the security price of the company for their own profit is considered as an insider. So who is an insider? An insider is a person who has some information about the company which can be used, right, by that person for making some gains, right, or can influence the share price. A person is considered to be an insider if he has been connected with the company in any capacity during 6 months prior to the concerned act, right. So, prior to the concerned act means if on a particular day I make some purchase or sale of the share, this is act. So, before 6 months of it, I am some way related with the company which makes me assess, to which helps me in assessing some inside information which is price sensitive, so that I will be considered as insider. So, a person is considered to be an insider if he has been connected with the company in any capacity during 6 months prior to the concerned act. The concerned act means the act which you have undertaken regarding purchase, sale of share, or making some contract with the company, right. So, it may be in the form of frequent communication with its officers through some ways, like if you are a supplier, right, if you are a buyer, you are making frequent communication with the officers of the company, and with the help of these communications you are able to get some inside information. Even then, in that case, you will be considered as the insider. Or holding any professional position in the company. Professional position may be an auditor, maybe director, or maybe senior employee of the company, or being a director, officer, or an employee of the company, means these persons are called the insiders. SEBI has regularly implemented fundamental changes to keep a watch on inside trading. Introduction of SEBI Regulation 2015 means 2015 itself the new regulations were being introduced, where the appointment of compliance officer is mandatory. In every company there will be a compliance officer who will check the inside trading in the company, that there is no inside trading that takes place in the company. Compliance officer is mandatory, who shall be responsible for legal and regulatory compliance of the policies, procedure, maintenance of records of the company to prevent any illegal trading. Regulation of unpublished price sensitive information. Like inside trading, that there are certain information which are called the price sensitive information, which are not published, which are not in the public domain. They are called the unpublished price sensitive information. Unpublished price sensitive information is any information which is not generally available and can directly or indirectly influence the price of the company's security, right. So, for example, suppose the people who are involved in the accounts department at the senior level of the company, they know in this quarter how the company is performing, what will be the results of the company, what will be the profit of the company. So, by using this information, you can influence the share price. Either if the performance is good, you can buy the share and make the share price, or you can pass on this information to somebody, right, and which will increase the share price, or vice versa. Means any information which is not in the public domain, and this information is of such nature which can influence the price, right. So, they are called unpublished price sensitive information. SEBI Regulation 2015 prohibits communication and trading by corporate insiders. So, Regulation 3 restricts the insiders to communicate companies any unpublished information to the outsiders. So, any person who has some information, unpublished information, they cannot pass it on to any other person who can influence the price of that. Regulation 4 prohibits insider to trade in securities when he is aware of any unpublished price sensitive information. So, such person cannot trade in the stock market, or cannot pass on any information which can influence the share price. Regulation 5 permits insiders to trade, means I am talking of where it permits to inside trade in securities in a compliance manner. Means there must be certain compliance, must be certain compliances that has to be made if you want to trade in the stock market who has some information. This provision allows an insider to create a trading plan that will allow him to plan for future trades. Regulation 6 and 7. I have talked about Regulation 4, Regulation 5. Now I am coming to Regulation 6 and 7. Regulation 6 and 7 requires disclosure by insider while trading in derivatives, not only in the cash market but even in the derivative markets. Trading in derivatives, and such disclosure shall be maintained by the company for at least 5 years. Regulation 8 requires every listed company to formulate and publish a code of practices and procedures for fair disclosure of unpublished price sensitive information on unofficial websites. So friends, today in this lecture I have talked about certain provisions, certain regulations that have been issued by the SEBI time to time, and idea of all these regulations is to protect the investors' interest. The very idea, very concept of this investor protection is that every investor must have a level playing field. They must have the same information, availability of the same information. The whole concept is based on that people should have trust in the stock market, in the capital market, so that people can work, people can have the confidence that the market in which they are dealing is transparent, is working under certain laws and provisions, and which helps them in order to have a capital growth, or the capital market can grow and the individual investor can also make growth with the growth of the Indian economy. Thank you very much.